Welcome to the Republican Professor. I'm your host, Dr. Lucas J. Mather. Today we're in the common use question on large capacity magazines, so-called large capacity magazines, because if it turns out that so-called large capacity magazines, LCMs, are in common use, then they're really standard capacity magazines. And large, the word large is a misnomer. It's really biased toward a specific policy outcome that people who favor gun control are advocating for. So we're in Judge Bumatay's decision, his dissenting opinion in Duncan versus Bonta. The original en banc panel was, I don't know, 4 panels ago. It's gone back and forth, up and down a number of times, which is really weird and awkward. Um, but we're in this wonderful dissenting opinion by Judge Bumatay. And so we're on the common use question, page 92. I'm shining my screen. You can get there by just Googling it. And I got this on the Ninth Circuit website, and the website is up there on the screen on YouTube for you to be able to see. For its part, California argues, says Judge Bumate, that plaintiffs here failed to satisfy their burden of proving that magazines holding more than 10 rounds are in common use for self-defense, which it argues is part of Bruin's step one textual analysis. Plaintiffs counter that the common use inquiry only comes into play under Bruin step two, and thus it's California's burden to prove. Conceitedly, Bruin is somewhat ambiguous on this point. It's mentioned in both the historical and textual steps of the analysis. Page 93 at the top. This question has divided panels of our court. Indeed, during the preliminary injunction stage, before the parties briefed this question, we assumed that the in common use inquiry was part of the Second Amendment's textual elements. Besides, the question of common usage of these magazines is undebatable. So, for this case, it didn't matter which side carried the burden of proof. Even so, after further briefing on the matter, we agree with plaintiffs that the common use inquiry best fits at Bruin's second step. We think this for 3 reasons. First, Bruin explained that the first step, whether the Second Amendment presumptively protects conduct, comes from determining whether the plain text of the Second Amendment covers the conduct at issue. And as a textual matter, nowhere in the text of the Second Amendment does, quote, common use, unquote, appear. Nor is common usage an inherent part of the definition of, quote, arm, unquote, which looks only at whether it's bearable, a bearable weapon of offense or armor or defense. Conducting the common use inquiry, I'm on page 94 now, going quickly, would be at odds with the fact that the common use test is not about the semantic meaning of the Second Amendment's plain text. Second, under Bruin's second step, the Second Amendment permits only firearm regulations consistent with this nation's historical tradition. And whether a firearm is dangerous and unusual or in common use is born from the historical understanding of the amendment. Heller itself directly tied the common use inquiry to the historical tradition of prohibiting the carrying of dangerous and unusual weapons. You'll notice that I'm emphasizing the word and. Okay. You'll see that gun controllers would love to switch that word and for or, which makes all the difference in logical analysis because and and or have different truth conditions, as you know from your truth tables, right? You took logic, right? Well, we're going to continue. If you haven't taken logic, take logic. Indeed, the in common use phrase originates from United States versus Miller, in which the court described the types of weapons colonial citizens would bring to militia service. Third, as a matter of constitutional law, it makes sense that California carries the burden of disproving common use. As the court has repeatedly said, the Second Amendment is a fundamental individual right. Once a plaintiff makes a prima facie showing of arguable fundamental right infringement, like in the First Amendment context, the burden shifts to the government to justify the regulation. In the First Amendment context, the government burden is extraordinarily heavy. So too here. Once a prima facie showing of a Second Amendment infringement occurs, page 95 at the top, by showing the government regulates conduct within the amendment's textual elements, everything else falls on the government. Since common usage of a firearm isn't necessary to prove prima facie Second Amendment infringement, it's the government's burden to carry at the second step. We turn there now. B, California fails to overcome the presumption of unconstitutionality because the plain text of the Second Amendment protects the possession of magazines capable of feeding more than 10 rounds. California's ban is presumptively unconstitutional. To rebut this presumption, California must justify its regulation by proving that its ban fits within our historical tradition of firearm regulation. California doesn't meet its burden. California supports its magazine ban based on 5 broad categories of historical analogs. 1, the prohibition of dangerous and unusual weapons. 2, laws regulating the carry of certain weapons. 3, prohibitions on possessing crossbows, slingshots, and automatic firearms. 4, bans on setting of trap guns, and 5, regulation on the storage of gunpowder. But given that California strictly bans the ownership, possession, and use of magazines in common use today, these traditions are not relevantly similar to justify California's magazine ban. Number 1, prohibition of dangerous and unusual weapons. So what he's going to do is he's going to go down this list of relevant analogs according to California. Okay. And he's going to just take it apart. And I mean, just looking at the list, you can already see where this is going. This is a pretty sad list. This is not a very impressive list for California. So no wonder California's their argument, recall from the last time, was that a magazine, if it holds 11 rounds or more, is all of a sudden not an arm. And Judge Bumatay called this the magic bullet theory, where you have 10 round magazines that are under, those are arms. They concede. California concedes, oh, yeah, those are arms. protectable by the Second Amendment. But 11 or more, all of a sudden it's not an arm. You can't make this up. That really was their argument. That was their argument. So all of a sudden you add a bullet and it's not magically it's not an arm, it's an accessory. That's what California was saying. Well, okay, so you have this he took care of that last time, arguing that that was a ridiculous definition of the term arm. It makes no sense. Judge Van Dyke takes that argument a step further, I think, develops it into a reductio ad absurdum argument, a pretty compelling argument that if that's where you want to go in arbitrarily defining the term arm into an accessory, basically calling whatever you want to ban an accessory, even if it's an ordinary part of the firearm and required for its functioning according to its design. Well, then if that's the case, then California could ban just about everything on the firearm, a typical firearm, maybe even the trigger, certain triggers. Um, so that you'd have you'd have maybe one shot, single shot firearms with ridiculous triggers that take 10 pounds of pressure or 20 pounds of pressure or something like that. It was an interesting argument. We're going to get to it in a bit, but we'll go back to Judge Bumatay here, his argument here. So again, we're on Duncan versus Bonta en banc, March 20th, 2023. Sorry, 2025. It's on the Ninth Circuit's website. Prohibition of dangerous and unusual weapons. Because the plain text of the Second Amendment protects, oh, sorry. Start with the prohibition on dangerous and unusual weapons. From Miller to Heller to Bruin, Miller was that Great Depression case about a sawed-off shotgun, in case you didn't know. Okay, page 96. The Supreme Court has recognized that the Second Amendment protects only the carrying of weapons that are those in common use at the time, as opposed to those that are highly unusual in society at large. As the court has explained, this understanding is fairly supported by the historical tradition of prohibiting the carrying of dangerous and unusual weapons. Thus, the court has suggested that dangerous and unusual weapons fall outside the Second Amendment's protection. So if California can prove that these magazines are highly unusual today, then that would be enough to satisfy its burden. But the magazines California bans are the furthest thing from highly unusual in modern America. In fact, firearms with magazines holding more than 10 rounds are the overwhelming choice of Americans for self-defense and other lawful purposes. While estimates vary, easily more than 100 million of these magazines exist in the country. According to one estimate, these magazines account for half of all American magazines. That's 115 million out of 230 million magazines in circulation today. Another estimate suggests that these magazines are even more prevalent, climbing to a staggering 542 million rifle and handgun magazines in the hands of millions of Americans across the country. Indeed, plaintiffs assert, and California doesn't contradict, that nearly 40 million Americans own or have owned magazines with capacity for more than 10 rounds. That's more than 10% of the nation's total population and about half of all American gun owners. Page 97. Given this widespread ownership, they are necessarily used for lawful purposes. And this common usage is nothing new. As we've seen, as we've said before, a clear picture emerges from our history. that firearms with large capacity capabilities were widely possessed by law-abiding citizens by the time of the Second Amendment's incorporation. And large capacity magazines have become common in this country by at least the late 19th century or early 20th century. In contrast, regulation of these magazines is unusual and new. Whoa. Now stick that on a coffee mug right there. The regulations are what is unusual and new in Second Amendment context and historical context. As mentioned above, three-quarters of all states have no magazine capacity limit like California. The federal government's short-lived experiment with the magazine ban lapsed by 2004. Aside from DC's law, most state bans were enacted after the 1990s, with many passed in just the last few years. Neither California nor the majority seriously challenge that these magazines are in common use. Instead, the majority buries the data. It claims that looking at ownership statistics is too simplistic and it disregards reliance on them as too rigid. But as lower court judges were not free to set aside the Supreme Court's directions so easily. Heller and Bruin were very clear. Once a firearm is in common use, it falls out of the historical tradition of prohibiting dangerous and unusual weapons and is entitled constitutional protection unless restricted by another tradition. In Heller, the court held that because handguns are the most popular weapon chosen by Americans for self-defense, on page 98 now, in the home, they are protected by the Second Amendment and their complete prohibition is invalid. Prohibition of an entire class of arms that is overwhelmingly chosen by American society for purpose of self-defense fails constitutional muster. On the other hand, Heller recognized that the Second Amendment does not protect those weapons not typically possessed by law-abiding citizens for lawful purposes. Bruin put an even finer point on this question. Assuming that historical laws could show handguns were considered dangerous and unusual in our nation's past, Bruin said that this history wasn't dispositive when handguns are in common use for self-defense today. So even if historical laws prohibited the carrying of handguns because they were considered dangerous and unusual weapons sometime in the past, they provide no justification for laws restricting the public carry of weapons that are unquestionably in common use today. How are you guys doing on this? Are you getting it? Is it making sense? One of the reasons I love this topic is because it's basic American government. It's basic American history. It it gets to the heart of constitutionalism, our ethnic identity as Americans. Do we live under a written constitution or not? Here, let me explain it to you. In ordinary statutory construction, you have statute 1, statute 2. Statute 2 comes after statute 1. If they conflict, statute 2 wins. But in a constitutional arrangement, you have Constitution, and then you have statute 1. Statute 1 comes after the Constitution, is in some way based on structures that are created by the Constitution. If they conflict, the Constitution is supposed to win. The older wins. In statutory construction, the later wins. Okay, the Democrats basically want this. They want to cherry pick based on their own little biases, which time they use constitutional analysis and which time they use statutory analysis, and they treat the Second Amendment like a statute that they can just overrun with a new statute. Okay. Now, when it comes to their sexual escapades and the desire to redefine the family into oblivion, they're more than happy to try to use constitutional analysis for what they want to use it for. But when it comes to basic things like the history of firearm regulation, then they just act like we're not even espousing a written constitution at all. It's just whatever you want to do. And so, this gets to the heart of that question of American constitutionalism. What has authority? So, the lesson of Heller and Bruin is that historical tradition of banning dangerous and unusual weapons can't justify regulation of firearms in common use today. Right? Am I there? Yeah. And because these magazines are no doubt in common use today, a tradition of banning weapons that are highly unusual in society at large can't support California's magazine ban. Next, the majority tries a different tack. Again, ignoring the Supreme Court's instructions, the majority claims that our historical tradition included dispossessing the people of especially dangerous weapons, no matter how commonly they were used for self-defense. Again, that's wrong. The court has always grouped dangerous and unusual together. We're on page 99 at the top. This Cayetano case is very important to get to. Guys, we need to do that. We need to do Cayetano on the podcast. That's the stun gun case coming out of Massachusetts. It was a woman who wanted to defend herself with a stun gun, and Massachusetts said, no, you have to wait for the police. You have to wait for the police. No, you can't use a stun gun to protect yourself. You have to wait for the police. You're a bad person. You're a criminal. That's what the Democrats were saying to women in Boston. And it's like, who are these women in Massachusetts? I mean, who are these people? It's like they have half their brain missing or something. And then you go into New Hampshire and everybody has their brain back. I don't know why it's so hard. But anyway, the plaintiff in that case was a woman. She won. Obviously, I'm not talking about her because she's on the right side. But, the people that vote these Democrats in to run Massachusetts and make these crazy laws and enforce them. I mean, how do you guys live with yourself? How do you guys even look at yourself in the mirror? Maybe you don't. I don't know. Maybe you comb your hair, looking only at the wall or something. I don't understand how you do it. How do you sleep at night? Shaming a woman for wanting to protect herself with non-lethal capabilities. It's just so bizarre. How's that pro-woman? I mean, forget the fact that you can't even define a woman anymore. How's that pro-woman? All right, let's continue. I'm getting fired up here. Yeah, Cayetano. We're going to do that one on the podcast. Okay. This is a conjunctive test. A weapon may not be banned unless it is both dangerous and unusual. Uh, in other words, whether a weapon is dangerous and unusual or in common use are different sides of the same coin. Um, in Kavanaugh's dissent at the lower court in Heller versus D.C., he observed the same thing. He said that dangerous and unusual weapons are equivalent to those weapons not in common use. Well, that makes sense. I think that what you're seeing here is it's the judicial branch has a tendency to step in a pile of doo-doo and not admit that it did it. And it just keeps stepping in the pile of doo-doo under stare decisis. I call it precedent. This is why we have so many bad precedents, because the values of judicial precedent and stare decisis, which have some legitimate angles and underpinnings. I'm not discounting it entirely, okay? I'm not saying Please, let's just hear me out for a second, all right? It's kind of ridiculous that we're using the term dangerous and unusual when we're talking about weapons. The very definition of a weapon is that it's dangerous. Uh, Otherwise, it wouldn't be a weapon. So, you're talking about weapons. That's what they are. They're dangerous. They're meant to be dangerous. Uh, if you use a weapon for self-defense, which is legitimate use of a weapon, then the whole point of it, if it's going to be effective for self-defense, is that it's dangerous to the person that's attacking you, that's immorally causing harm and criminally um, victimizing you, right? To have strength to oppose that effectively requires danger toward the criminal. It's so basic. I don't understand why we're using this dangerous and unusual. Why don't you just say anyway? It's one of those piles of doo-doo that the judiciary stepped in, and then they just keep stepping in it. And what am I going to do? What am I going to say? I said it. I said what I needed to say. I'm John Mayer. Said what I needed to say. Say what you need to say. Indeed. Oh, yeah. Indeed. Like the majority here, the dissent in Heller tried to justify the DC handgun ban by arguing that an outright prohibition is necessary where a governmental body has deemed a particular type of weapon especially dangerous. Oh, man. Of course, the court rejected this view. A governmental body. Ooh. Okay. Yeah, of course the court rejected this view. Let me just rephrase that. The Republican court rejected that view correctly. And since it didn't work against the commonly used handguns, it won't work against commonly used magazines. Perhaps trying to evade Heller's clear ruling, the majority tries a new twist, recharacterizing the tradition as a ban on especially dangerous uses of weapons once the threat to innocent persons has become clear. But that move fools no one. It is simply a retread of the same argument. And the bottom line is this: neither the majority nor California has identified any historical regulation dispossessing law abiding citizens of commonly used weapons for self defense because they were especially dangerous. So this purported tradition is made of thin air. Incidentally, that Cayetano, the stun gun case that I mentioned, and he mentioned, the lady in that case, uh, I think, claimed that they were in common use, and they are far less common than so-called large capacity magazines. So a fortiori, if stun guns are common, and the Supreme Court has said they are in Cayetano in 2016, a fortiori, then uh, the standard capacity magazines are far more common. So they're common. You guys following what I'm saying? If you don't know what a fortiori means, look it up. If it's not under A, it's under P. Just look it up. Anybody else seen Scrooge? Look it up in the phone book. A and P. If it's not under A, it's under P. All right, never mind. I guess I watch too much TV, or I just like Christmas movies. We're on page 100 at the top. 2, laws regulating the carry of weapons. California next relies on the tradition of regulating public carry of certain weapons to justify its regulation. I'm turning to this side. Okay. You know what I mean, Vern? To be sure, these types of laws have been around a while. Anti-carry laws trace back to the 14th century England as well as colonial, founding era, and antebellum America. These historical regulations, of course, differed. Most forbade concealed carry, while some forbade open carry for certain illicit purposes, reflecting the sensibilities of the jurisdiction at the time. Only a few banned all public carry of specific weapons, while others required intent, whether the carry was meant to frighten or threaten. The through line of all these regulations, however, is that none broadly disarmed law-abiding citizens. And I'm going to add something here. I don't have to add much here, but I'm going to add this comment that he made about intent, whether the carry was meant to frighten or threaten. We're assuming quite a bit there. We're assuming that the a person you're trying to frighten or threaten is not a harm to you in a criminal sense. Now, self-defense, of course, if some of the most effective self-defense is non-lethal and it avoids escalation. And the way it avoids escalation is precisely to present yourself as a threat to the criminal, to threaten the criminal, to frighten the criminal, because some of these immoral criminals need to be frightened of you, of innocent people, right? Does that make sense? Because of that's how you, for example, in the war context and international relations, isn't it true that strength, presenting yourself as strong, it deters evil action and evil actors. So, for example, in the case of Ukraine, if Ukraine could frighten or threaten the aggression from Russia, well, then it's unlikely that Russia would have invaded. It's really basic. This is basic. So all of my point is this language of frighten or threaten, it doesn't have the moral import that Judge Bumatay assumes. And you have to add that explicitly with language. Frighten or threaten is not itself immoral. You have to add the context. And the context is, are you a victim of immoral crime? Right? And even the word crime has to be clarified because a lot of these crimes are crimes that shouldn't be crimes. They are criminalization of innocent conduct, where the innocent person is regarded as a criminal. Right? Are you guys following this? Does it make sense? Take, for example, I've said this before, Blue Bloods. I love the show. My grandpa loved the show. Um, it's a Republican show. The very first episode was about public carry, illegal public carry for not for immoral purposes, for moral purposes, for self-defense. The guy was innocent. Innocent conduct was criminalized. And so you got these people trying to figure out what to do. They're going to hurt an innocent person if they enforce the law. You change the law. You change the law. It should never have been criminalized in the beginning. And the same with this. So many gun control laws criminalize innocent conduct. And I think criminalizing innocent conduct is one of the worst things you can do, whether as an individual or as a government. All tyrannies criminalize innocent conduct. That's what they have in common, whether they're authoritarian or uh, ter- um, whether they're communist, whether they're fascist, whether they're socialist, whatever kind of socialist they are, national socialist or so-called international socialists, they're all national socialists. I mean, give me a break. This is what defines the not only the authoritarian, but the tyrannical governments that we normally think of as totalitarian. Okay, let's keep going. Am I right or am I right? California begins with the Statute of Northampton, 1356. Wow, that's pretty desperate. As Blackstone described the English law, the statute prohibited the offense of riding or going armed with dangerous and unusual weapons while terrifying the good people of the land. Well, see, there, the moral language is right there. Good old Blackstone. Although it was certainly concerned with the wearing of armor, it's accepted that it applied to weapons like the lance to the core of the statute was notable for two reasons. First, the statute didn't apply to common weapons like medieval daggers, which could be most analogous to modern handguns. I agree. Concealable and deadly. Second, the statute applied only to those who carried weapons with evil intent or malice. Yeah, that's right. Yet, see, you hear the moral language? It's right there. Good, the word good, evil, malice. Yet, California's ban applies to everyone, regardless of intent. All in all, the court concluded that the English law couldn't justify restricting the right to publicly bear arms, such as handguns, for self-defense today. Thank God. By the way, only Republicans striking down these amoral and immoral laws. Democrats defend. Page 101 at the top. You guys hanging in there? We're cruising through this. Good job. All right, so let's continue. The earliest American law cited by California dates to 1686. Then the Quaker province of East New Jersey prohibited the concealed carrying of pocket pistols, uh, skeins, stillators, daggers, or dirks, or other unusual or unlawful weapons because they induced great fear or quarrels. All right. Hmm. These Quakers, got to watch them. Massachusetts followed with other carry regulations, although it only targeted armed groups. Um, an act to prevent. Okay. Skipping down. California claims that other states enacted anti-carry laws for clubs and other blunt instruments. California next looks to historical laws limiting the carry of Bowie knives, concealed weapons, and pistols. California contends that by 1840, a handful of states implemented laws regulating carry of Bowie knives, and that those restrictions eventually spread to most states by the end of. Footnote 9 is interesting, but we're just going to continue. Page 102. By the end of the 19th century. California also observes that by 1838, a handful of states had laws banning the concealed carry of weapons such as pistols, dirks, sword, canes, and spears. Finally, according to California, several states responded to an upswing in violence from the proliferation of percussion cap pistols in the first half of the 19th century by restricting carry of concealable pistols. The majority identifies two late 19th century laws banning carry of concealable pistols. Interestingly, courts in Tennessee and Arkansas struck down early versions of the laws because they applied to repeating or military style revolvers. Awkward, 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 awkward. Wow. That is awkward. Here's footnote 10, a little bit of footnote 10. I mean, these footnotes are really interesting. Let's go back to footnote 9. As examples, California points to an 1836 Tennessee statute, an 1839 Alabama statute, but neither law was a sweeping ban on the carry of Bowie knives. The Tennessee law only prohibited wearing a Bowie knife under his clothes or otherwise keeping it concealed about his person, selling Bowie knives, and cutting or stabbing another person with a Bowie knife. Well, that's nice. Yeah, that's nice that you prevented stabbing. And the Alabama law only regulated concealed carry of any Bowie knife and any species of firearm. An act, okay, so, and listen to the name of the act, an act to suppress the evil practice. Okay, so they're clearly trying to figure out how to prevent murder. One good way is to say you can't do murder, you're going to be punished. Footnote 10, California has identified no laws banning the possession of Bowie knives. That's interesting. All right, so I'm not going to read all of the footnotes. You can read those. We're on page 103 at the top. Regardless of tradition, to regulate the carry of certain weapons, these laws cannot justify California's ban on the ownership and possession of magazines holding more than 10 rounds. Bruin dictates this conclusion. In that case, New York relied on the same regulatory history as California to show that states may restrict the public carry of firearms. The court agreed that the historical evidence from antebellum America demonstrates that the manner of public carry was subject to reasonable regulation. Even so, that robust history was not enough to prevent law-abiding citizens with ordinary self-defense needs from carrying arms in public. And the key issue in that case was, of course, that ordinary citizens should not have to have the burden of proof uh, to exercise this right. That any law criminalizing such a right, exercise of a right, the government supporting that law has to have the burden of proof and justifying it against the individuals. All right. Well, the answer is simple then, right? If historical regulation of the carry of certain weapons is, in certain situations, not relevantly similar to modern law prohibiting the carry of all weapons without a license, then those laws cannot be analogous to California's law preventing law-abiding citizens from possessing firearms for self-defense purposes. Put differently, if targeted historical carry laws don't justify wide-ranging restrictions on the carry of commonly owned weapons, they don't support the outright ban of commonly owned weapons. Makes sense to me. Under Bruin, we can't extrapolate from narrow regulations a justification for much broader regulations. While anti-carry laws limited the intent for which one could carry arms, the manner by which one carried arms, or the exceptional circumstances under which one could not carry arms, on page 104 at the top, California's law prohibits all conduct at all times and all places, even in the privacy of the home. See, that's how extreme the Democrats are now. And Heller made clear that the needs for self-defense of self, family, property is most acute in the home. Wow. While historical carry restrictions may burden the Second Amendment right in one limited fashion, California's magazine ban is different in scope. It's a complete dispossession of a commonly owned arm. Rahimi further signals the mismatch between the tradition of carry regulations and California's magazine ban. In Rahimi, that was last year, in 2024. We're going to cover it on this podcast. Don't worry. In Rahimi, the court determined that historical surety laws and going armed laws supported the modern regulation of disarming those under a domestic violence protection order. That's because both the historical tradition and the modern regulation shared the same how and why. Both served the purpose of disarming individuals found to threaten the physical safety of another. And their burdens were comparable. Okay. The temporary disarmament after a judicial determination of a particular defendant's dangerousness. In contrast, Rahimi observed that the law struck down in Bruin broadly restricted arms use by the public generally. That makes sense to me. That makes sense to you? So while a tradition of targeted and temporary disarming of dangerous individuals, and this is judicial determination. It's not just a legislative determination. It's judicial. It's a particular case, okay, with evidence presented. And due process. There should be due process. If there's not due process, there's got to be a huge problem with this. But we'll cover Rahimi later, okay? But that has to do. His argument so far is just we're not talking about the public at large in Rahimi. We're talking about individuals, right? And that was an extreme case. The Rahimi case was an extreme case. I mean, if you read that. Okay, let's keep going. In contrast, Rahimi observed that law struck down in Bruin broadly restricted arms use by the public generally. So while a tradition of targeted and temporary disarming of dangerous individuals may exist, that wouldn't justify any broad-based permanent dispossession. So too here. Limited historical laws designed to prevent confrontation, fear, and terror in public can't justify a modern law that prevents all individuals from ever possessing a commonly owned arm for self-defense. In other words, we can't extract any principles from the tradition of carry laws to fully dispossess law-abiding citizens of arms in common usage. We're at page 105. 3. Laws banning possession of certain weapons. California also identifies a handful of laws throughout history that banned the outright possession of a weapon. None are relevantly similar. None are a relevantly similar analog to California's magazine ban. California cites an English law from 1541. Jeez. Wow. Way off the mark. That prohibited persons with an annual income below 100 pounds from possessing a crossbow without a license. The law is closer to California's law since it appears to prohibit outright possession of a weapon, at least for certain classes of people. But by the 1700s, this law was widely considered obsolete and so restrictive that the court considered the law as not incorporated into the Second Amendment scope. California, that didn't stop California from using it in argument here at the Ninth Circuit, did it? Freaking Democrats, man, holy cow. You're just wasting our time. You're just wasting our time, aren't you? California points to a late 19th century state laws against slingshots. Slingshots refer to a wide range of handheld weapons for striking, often with a metal or stone attached to a flexible strap or handle made of rope, leather, or other material. By the way, we had a guy that's an expert on this on the podcast last year. Was it last year? His name is Alan Beck, and a wonderful guest. He's a Second Amendment attorney working in Hawaii, and he has really, brought back slungshots in Hawaii. You can have a slungshot on the beach in Hawaii. You can have a samurai sword now in Hawaii. Love it. And we had him on the podcast. His name is Alan Beck. Look him up. Look up that episode. I don't get paid anything more if you don't look it up. So whether you look it up or not, it's up to you. If you want to learn something, look it up. But if you don't, I can't help you. Sorry. We're going to continue. California points to these slingshot. Okay, so between 1849 and 1890, 9 jurisdictions prohibited the sale and manufacture of slingshots. Only Illinois banned their outright possession, while the other, on page 106, jurisdictions prohibited their carry. Most other states enacted laws against the carry of slingshots by the late 19th century. Even if these laws come from the historically relevant period, they don't serve as proper analogs for California's magazine ban. Simply, slingshots were not commonly used for self-defense. As California expert observed, they were widely used by criminals and street gang members with no noted historical use for self-defense. Indeed, according to one source, while court records of the 1800s have many cases of civilians using slingshots, a man bringing one out after being threatened comes up rarely. So these slingshot regulations don't evince a historical justification for regulating weapons that are used to facilitate armed self-defense for other lawful purposes. Further, the burdens of slingshot regulations and California magazine restrictions are dissimilar. Historically, most states restricted only the carry of slingshots, very different than an outright ban. And by the way, according to Alan Beck, if I'm recalling this correctly, the guest on the podcast last year, 2024, he mentioned that this is a poor man's weapon for self-defense. If you couldn't afford a firearm or ammunition, well, then a slingshot. If and it was also certain minority communities that used them, and so Hawaii was really oppressing certain minority communities. If you want to know the truth about it, that's why he won. At least that's the reasoning he gave, and he won. Um, yeah. So, but we're talking about the carry here. That's different than outright ban. Just one state banned their possession, not enough to suggest a widespread historical tradition. Um, all right. Page 107. Finally, California raises a 20th century restrictions on automatic and semi-automatic firearms as historical analogs. According to California, from 1927 to 1934, over a dozen states restricted fully automatic and some semi-automatic firearms. We can make short work of this argument. These laws were enacted nearly 140 years after the Second Amendment's ratification and 60 years after its incorporation. That's simply too late to help define, there's a split infinitive, uh, to help to define the meaning and scope of the Second Amendment right. The Supreme Court has made clear that our inquiry of regulations is at most cabined to the period through the end of the 19th century. And even then, the late 19th century history may be too distant. Today's decision would not be understood. Okay, blah, blah, blah. Skipping down. So we can safely say that the 20th century is not a relevant time frame for this inquiry. In sum, this survey of history shows no robust historical tradition of disarming law-abiding citizens of commonly owned arms used for self-defense. Indeed, the lack of outright weapons bans is telling in and of itself. From colonial America to founding era America to antebellum America, save an outlier or two, no laws banned the possession of any type of weapon. I think cane swords were an exception. Cane guns or cane swords. Wow. It's starker when looking at firearms bans. As the district court observed, between 17th century English laws and 19th century state laws, California has not identified any law anywhere at any time that prohibited the simple possession of a gun or its magazine or any container of ammunition, unless the possessor was an African American or a slave or a mulatto. So that's what Democrats think of you. They think of you the same way the Klan thought about a slave or an ex-slave. That's how they think about you. They defended slavery too. Democrats defended slavery. Wow. So if anything is trapped in amber here, Judge Bumatay continues, perhaps it's the historical understanding. Page 108 at the top. That law-abiding citizens may choose any commonly owned firearm for self-defense without government interference. Laws against trap guns. We're getting close. We're getting close. How are you guys doing? You hanging in there? Let's switch sides here so you can see the other side of my tie and you can see whatever pens you might be able to see in my pocket. Okay, let's go to laws against trap guns. We've got just a few more pages here and we're going to be done for today, okay? All right. Hang in there. California's reliance on trap gun regulations is even more far afield. Trap guns were contraptions using string, wire, or other contrivances to remotely discharge a firearm. Historically, they were used to thwart thieves from robbing businesses or properties, and sometimes for hunting. According to California, only 11 states regulated trap guns before the 20th century, and only one was from the 18th century. New Jersey's 1771 law banned a most dangerous method of setting guns, an act for the preservation of deer and other game. Okay. The rest of these laws came into effect in the mid to late 19th century. Even assuming these laws are temporarily significant, they would not implicate the Second Amendment. Trap gun mechanisms aren't protectable arms under the Second Amendment's text. Page 109 at the top. To start, they're not bearable. On the contrary, a whole design of trap gun was to allow a firearm to be discharged without a person needing to keep or bear it. So trap guns are not weapons to wear, bear, or carry upon the person or in clothing or in pocket for the purpose of being armed and ready for offensive or defensive action in the case of conflict with another person. Nor can a person take a trap gun into his hands or useth in wrath to cast at or strike another. And they are not integral components of a firearm. So the majority is just simply wrong to claim that the trap guns were used for armed self-defense. Indeed, the majority mistakenly suggests that homeowners rigged trap guns in defense of their homes. But nothing in the record supports that trap guns were used in such an improper way. And I mean, I think the issue here with trap guns is that there's no person that's monitoring it to make sure it doesn't hurt an innocent person. And they did hurt innocent people. That's why there was an attempt to ban them. Okay, but let's continue. Given all this, it's hard to see how trap guns fall under the Second Amendment's textual elements. But even if trap guns constitute arms, the burden of regulating trap gun mechanisms are not analogous to burdens of California's magazine ban. First, California identifies no historical regulation that prohibited the possession of a trap gun. Like New Jersey's law, most states prohibited only the setting of the device. Other states only forbade their setting for hunting or for injuring another person. But the broad disposition of an arm is different from preventing individuals from rigging a firearm with a contraption to fire it automatically. Makes sense to me. The why of trap gun regulations is also very different. As a majority must concede, these regulations were meant to prevent the occasional tripping of trap guns by innocent persons. California didn't ban magazines holding more than 10 rounds to limit accidental firearm deaths. Rather, the purpose of a magazine ban was to respond to intentional gun violence. Laws regulating gunpowder storage. We're on page 110. Finally, California relies on 18th and 19th century gunpowder storage laws. Concerned with the dangers of massive fires and explosions, these laws prohibited the stockpiling of large quantities of gunpowder in one place. An 18th century law, for example, made it unlawful in New York City to have or keep any quantity of gunpowder exceeding 28 pounds weight in any one place less than 1 mile to the northward of the city hall. An act to prevent danger arising from pernicious practice of lodging gunpowder in dwelling houses, stores, or other places. Another 1821 Maine law regulated how much gunpowder could be possessed and stored by a person for the prevention of damage by fire. These gunpowder storage restrictions don't establish a historical tradition supporting California's magazine ban. First, these laws offer no comparable burden on the possession of a firearm. While California's magazine ban prohibits using the most popular magazine for self-defense, the gunpowder laws had zero effect on self-defense. Wow. They did not clearly prohibit loaded weapons and required only that excess gunpowder be kept in a special container or on the top floor of a home. So they regulated the accumulation of excess explosive material by limiting where it could be stored. They didn't prevent citizens from having ammunition at the ready for self-defense. As the Supreme Court observed, when this history was used to defend a handgun ban, nothing about the fire safety laws undermines our analysis because they do not remotely burden the right of self-defense as much as an absolute ban on handguns. Second, the why is also obviously different. These laws targeted the danger of accidental explosions and widespread fire posed by improperly stored gunpowder. In contrast, California's purpose in enacting its ban was to reduce intentional gun violence. So this tradition does not support California's magazine ban. In sum, the right to keep and bear firearms that use a magazine able to hold more than 10 rounds is presumptively protected by the text of the Second Amendment. These magazines constitute arms because they are necessary components of firearms and facilitate the firing process. Thus, California has the burden of identifying a historical analog that is relevantly similar to a ban on these magazines and has failed to do so. Simply, no historical analog justifies California's absolute ban on magazines that come standard with most firearms. While dangerous and unusual weapons may fall outside the scope, the Second Amendment scope, arms in common use today, like magazines holding more than 10 rounds, clearly don't. And though the Second Amendment seemingly permits reasonable restrictions on the public carry of some uncommon weapons, that's not comparable to California's outright prohibition of the most popular magazine for self-defense, and the lack of any historical regulations banning the possession of a common firearm further undermines California's law. Finally, with no impact on armed self-defense at all, the regulations on trap guns and gunpowder storage are not remotely close to the burden and justification for California's ban. Because California failed to meet its burden, California Penal Code 310 is unconstitutional. The next section is the return of interest balancing, Roman numeral 3. This is the key part here. All of this is key, but this is really, he nailed what's going on here. And so we'll be very interested to finish the argument that he proposes there. Well, basically, he's arguing in the next section that the Ninth Circuit is just going back to how they used to do things and just ignoring the standard of review appropriate to Second Amendment cases as set forth by very reasonably by the Supreme Court. So we're going to get to that next time, and that'll be a shorter. It's about half the length, I think. Maybe not quite half. Maybe a little bit more than half. Looks like it's about 65% of what we just went through. So it'll be a shorter episode next time. And thanks for joining me on the Republican Professor podcast. Today is 15 May 2025. And we're happy to have you join us on the Republican Professor.